is Jeff Risch with SmithAmundsen. Good morning, everyone. We are going to be discussing some latest local, state, and federal mandates surrounding the virus and what's going on. We actually did this webinar yesterday, and I've been working. I worked last night and this morning on updating it because things change by the hour, literally changing by the hour. So we have more information to share this morning, a little bit more detail. You will have questions. Those questions will be answered, but it's not going to be on this webinar. One, we can't tie up the line that long. We've got to be a little careful with just the capacity. Number one. Number two, we just don't have time. We will be inviting you to type in your questions and submit. Our marketing department is capturing those questions, and we'll be sending the questions to relationship attorney or to myself, and we will be answering those questions as quickly as we can and as efficiently as we can with the best information that we have available. So with that in mind, we will be reaching out, following back up. The slides will be made available after the presentation, will be emailed out to those attendees and participants. And again, please reach out, whether it's SmithAmundsen or your other firms that you're using, you're partnering with those questions, and get those questions answered as best as you can in real time. Everything is fluid, and today's discussion is to try and help provide some more information and really things that you should be thinking about to protect your business and to protect your workforce. So with that in mind, a slight delay in the, and I don't know what the issue is here, but we all already have a. So I don't, if for those of you that have been looking at the House Bill 6201, President Trump did sign that into law, I think in the wee hours today. It was passed by the House of Representatives on March 14th in the wee hours. That bill, there was when that bill was introduced originally, there were some concerns, of course. How does this affect small business? How does it affect large business? And there were a lot of questions that were being discussed in Washington. Over the weekend, the House continued to work on that bill, and on March 16th came up with a revised proposals. Those proposals were sent to the Senate. The Senate, we're discussing it yesterday. Thank you. The Senate was discussing it yesterday, and we are we now have a final bill that was sent to the president late last night, and he signed it. So we're going to get into 6201, the relief package, in just a moment. But the initial thoughts as we begin the webinar is there's no uniform path forward. Different industries, the type of business, whether you are called an essential business or you would be found to be an essential business versus a non-essential business, and we're going to discuss that this morning. That's all fluid, and you have to continue to pay attention to your local mayor and what the authority from the mayor's office to the governor and your governor, as well as federal mandates that are being worked out and are being that are, whether they're in place or they're being worked out in real time as we speak. The purpose of today's discussion is to just help you, educate you, give you the latest information, and really highlight your rights and responsibility as employer. With regard to the rights and responsibility as employer, all advice that I'm giving, folks, I don't have all the answers. I can just give you, based on the information that I have available at this moment in this hour, I can just give you my best opinion and insight. The two most important things that I am conveying to my clients, to my businesses, to my customers, to anyone and everyone is two things that are going to shape your decision making: the health and welfare of your workforce, the public, and the ability to operate your business as effectively as possible. And now, with some of the orders that are being handed out, you might not have any choice but to operate your business at its fullest capacity possible. The latest, the greatest is House Bill 6201. I've got the latest. I'm going to give you the summary as best I can. There's going to be nuances. There's going to be questions, and I'm going to try to address it as best I can. Mandated business closures. What does that mean? Non-essential versus essential. We've got shelter-in-place orders. What do those mean for my business? I'll talk about that as well. We're also going to discuss school closings, unemployment development, the paid sick leave mandates on a local and state level, and your own benevolent policies, remote work issues, specifically to wage and hour law, furloughs, layoffs, and WARN considerations. So there's a lot to discuss. Trump signed House Bill 6201 into law. It's the Families First Coronavirus Response Act. There are many pieces to this. Testing, medical care. I'm focused on three from an employment standpoint: paid leave, expansion of FMLA leave, and expansion of UI benefits. So those are the three main mandates. They're in effect, will be in effect no later than April 2nd, because the law said it would be in effect no later than 15 days following signature. Trump, I believe, signed it either late last night or in the wee hours this morning. The mandates are set to expire on December 31st, 2020. So what we're looking at here are three components. Let's start with paid sick. All private sector employers with less than 500 employees, all government employers with any employee must pay the employee 2 weeks of paid leave, up to 80 hours. For full-time workers, or if they're part-time, the average number of hours worked in the standard 2-week period of time. If you are a private sector employer with 500 or more employees, regardless of the location, you are exempt from this law, from this mandate. Paid sick leave will be provided to any employee who is not able to work or able to work remotely under certain conditions, and there are certain conditions, okay? So we don't have to worry about this unless we don't have to worry about this if we have if we have 500 or more employees. But if we have less than 500 employees, or we're a government employer, we have to provide employees up to 2 weeks of paid leave, 80 hours, the equivalent of 80 hours for full-time, or whatever their average hours are in a given 2-week period if they're part-time. We will not have to pay the employee if they're able to work, remotely. If they're not able to work or not able to work remotely under the following conditions, and only under the following circumstances, if they're not able to, we would then have that obligation to pay. So if an employee is not able to work and can't even work remotely because the government has ordered them to quarantine, if they've been advised by their doctor to self-quarantine, and again, this is all related to this virus, nothing but this virus, COVID-19, if they're experiencing symptoms and they're seeking medical help, medical diagnosis, if they are caring for an individual subject to quarantine order or self-quarantine, if they're caring for their kids being under 18 years of age because schools are closed and they don't have childcare available. So I cannot work because of what's going on, preventing me from working at the office, at the plant, in the field, or remotely. Then I have that benefit in place for 2 weeks. There's also a catch-all category for other substantially similar conditions that we don't know, and this is fluid. So let the Secretary of the Health and Human Services consult with other federal agencies to see if there's other things we need to add to this list in the days and weeks to come. Employers with less than 50 employees, you are considered a small employer under this law. And if you have less than 50 employees, you may be exempt. The Department of Labor is going to be publishing, I imagine they'll come out very quick. The Department of Labor is supposed to come out with regulations that will guide the small employers through this possible exemption. The exemption is triggered if the viability of the business is in jeopardy, meaning if I have to pay out this leave, I'm going to have to shut my business down. That's the intent behind that. So it's a pretty narrow exemption or exception. There's also an exemption for healthcare workers and emergency responders. That's a limited exemption for people that are actually providing medical care. That wouldn't cover janitors or receptionists or admin folks. It's the actual in-the-field responders. There's an exception for them as well under this law, regardless of size of the employer. The paid leave appears not to be intended to be in addition to other paid sick leave policies or local or state mandates. That's a wrinkle that we're still trying to iron out. And we have the summary that's appearing here in the webinar. We have the summary on our blog page, laborandemploymentlawupdate.com. We continue to update that daily, sometimes a couple times a day. We will have some short Q&As on our blog page as we continue to unravel this. Like I said, it just came down late last night, and we're still getting our arms around the nuances of the law. But it seems to be there may be a legal argument that it would not be intended to be in addition to other leave mandates or other leave benefits that may apply. There's nothing in the law that says an employer cannot change its paid time off policies, not retroactively, but prospectively after the effective date. And that's interesting to note. The amount of this paid leave is capped. Employees are compensated at the higher of their regular rate of pay, the federal minimum wage or the local minimum wage, so whatever is greater, but not to exceed. So there's a cap of $511 per day and $5,110 in total for each employee affected. So that is there's a definite cap. Now you may be asking yourself, if there is the ability to apply other mandates, why would I apply this? Because there's a tax incentive, there's a tax credit. if each quarter private sector employers are entitled to a tax credit equal to 100% of whatever sick leave wage is paid under this law. There's also another sort of cap. If an employee must care for a sick family member, so it's not for them, but it's for their family, or to care for a child, right? Because they have to care for the child, like unable to attend school, then they are not to be paid their full regular rate. They are only to be paid 2/3 of that rate, but not to exceed $200 per day or $2,000 in total for this 2-week period of time. So a little confusing? Yes. You're going to have to, I don't expect you to read this and be like, oh, this makes perfect sense. I know exactly what to do. No, it doesn't work that way. You're going to have to give thought to these words. You're going to have to look at this and look at this with your existing paid mandates and policies in hand as well. And if this really was not intended to be in addition to, a lot of companies are seeing the same language that I've highlighted here in point number 2, and they're asking, well, I might just go with our own policies and our own legal mandates. I might not want this tax credit. That's something, again, that's a wrinkle that we're trying to iron out, and that's probably going to be something that's going to be unique to your business decision making in the days to come. But the point of the paid sick leave is to provide sort of a minimum and a maximum guaranteed paid sick leave when an employee needs to be gone because of the virus. And if it's for their own health, they're going to get full pay. If it's to care for a family member or to care for kids because schools are closed, it's going to be at a 2/3 rate. Now, due to concerns over the employer's cash flow, and everybody has concerns over cash flow right now, the U.S. Treasury Secretary has broad authority under this law to do what it can to help employers meet their financial obligations. So because when this first came down on Friday or March 14th, in the wee hours of March 14th, the first response or first reaction that I had waking up on March 14th was, how are employers where are they gonna get this money? There are cash flow issues, especially for employers that don't have reserves or don't have line of credits, or their line of credits are being maxed out. So there is a signal from Washington that the U.S. Treasury Secretary has broad regulatory, which I interpret to mean we're going to see more guidance from the Treasury's office on this issue to help employers meet their financial obligations. The employer can also seek a tax credit to offset any cost of continuing to provide health insurance when employees are using this benefit, and all payments made. Another advantage of this mandate is these benefits are not considered wages for Social Security tax purposes. And what's interesting is self-employed individuals can also receive the same tax credits as if they were employed by an employer under this mandate. The second component of the law dealing with employers is a paid family and medical leave component. A lot of employers, especially smaller employers under 50 employees, didn't pay attention to FMLA. Well, now you have to, in a limited way. Let's take one small step back and breathe for a moment. The FMLA, for those that have 50 or more employees, it continues, right? It hasn't been suspended. So you all know, as a regulated FMLA employer, if you have 50 or more employees, your employees can take up to 12 weeks of unpaid time off to deal with a serious health condition for themselves or for their family. Right? That hasn't changed. Where they went with this FMLA, originally it was pretty expansive, but the final version that Trump signed, that went through the Senate, limits this FMLA wrinkle that was added to this bill. So let me explain what this wrinkle is. All private sector employers with less than 500 employees and all government employers must provide any employee who has been employed for 30 calendar days or more up to 12 weeks of paid family and medical leave in order to care for children under 18 if and when schools are closed, daycare is closed, daycare is unavailable because of COVID-19, and the employee is unable to work remotely. I mean, those are two big conditions, right? I mean, that's a lot of people are working remotely. A lot of people are working remotely with screaming kids in the background. This would not apply to them. This would not apply to them. If you can work remotely and schools are closed, this doesn't apply. If you can work remotely, and your child, nobody's taking care of your kids, this would not apply. This would only apply when schools are closed, daycare is unavailable, and the employee is unable to work or work remotely. There's no 75-mile radius or hours worked requirement. Any employee, as long as that employee's been with you for 30 calendar days or more. I don't care how many employees you have here or there in Timbuktu or Peoria or Rockford or San Jose. If the criteria is if you have less than 500 employees, this would apply to you. You might have less than 50 employees. No other component of FMLA is going to apply to you except for what's on the screen. If you are a private sector employer with 500 or more, regardless of location, you're exempt. Now, whether or not you combine employees and we're getting this question. Well, what if we are, whether we're on an umbrella, we're under an umbrella. There's a holding company, and we're part of all these different entities. It really comes down to control. If there's common control, those employees are going to be lumped together. If there's no common control, everyone is operating separately, separate, distinct legal entities, then they would be considered on their own. The analysis under who is an employer and how many employees you have under the FMLA didn't change with this law. That the same analysis before applies today under this law as far as counting employees and not counting employees and who's considered a common control employer joined at the hip with other businesses to add up to those numbers. I can tell you this, if you start to distinguish now when you didn't distinguish before, that's not going to work. You cannot now change your shape and your control just to try and get out of this law. I don't think that's going to work. After 10 days, remember that 10 days, because the first 10 days in theory would be paid, right? I mean, if somebody can't come to work or they cannot work remotely because they're dealing with the virus, remember they're going to get paid. They're going to have some paid component to that. After the 10 days, the employee, if they still can't work because they're unable to work because of the virus, or they can't work remotely because, they just can't, their job doesn't allow them to work remotely. They would be entitled to additional pay at the rate of 2/3 their regular rate of pay, not full 2/3. Now there's caps. The paid leave component here is also capped. The caps are $200 per day and $10,000 in total. And private sector employers will still be entitled to that tax credit equal to 100% of what they're paying in that FMLA benefit. But ladies and gentlemen, take a breath. That FMLA benefit is there. That 2/3 benefit is only going to come into play in very limited, narrow situations where employees cannot work because of child care issues for those under 18 years of age, while schools are closed, while child care centers are closed. It's very narrow and hopefully extremely limited in time. So I don't, we'll see where this goes. I think more and more companies are trying to think of ways to allow as many people with the child care issue to work remotely from home. If that's not possible, then that employee would have the ability to take advantage of this limited pay component. 2/3 of their regular pay, not to exceed $200 per day or $10,000 in total during this crisis. If you have less than 50 employees, just like with the paid sick leave mandate, same thing, you can be exempt. If the viability of your business is in jeopardy, you can be exempt. Such employers will not be subject to civil penalties for violating the leave mandate either, those small employers. So that's interesting. And there's that exemption for those actual healthcare workers and emergency responders delivering medical treatment and healthcare services. They can be excluded at the discretion from this FMLA component of the employer. In other words, hey, I know you have to take care of your kids. You are a medical doctor. I need you at the hospital. You have to be at the hospital. If that exemption is in place for these healthcare workers. Again, the cash flow issue, same thing, because there's a paid component. This works very similar to what we discussed with the paid sick leave. Again, self-employed individuals can take the same tax credits, but for up to 50 days. So they could get that 2/3. I'm self-employed, but I got to take care of my kids. I can't work from home. So I'm going to get 2/3 pay for the days that I can't work taking care of my kids, and that would be up to 50 days for self-employed individuals. The third bucket to fill with 6201 is the unemployment benefits expansion. This should not hit employers as chargeable employers. We'll see, each state is going to do this a little differently, I imagine, but the federal government is allowing and encouraging states to be more flexible with respect to eligibility. So the federal government will provide states $1 billion in additional funding for UI benefits. But here's where it's going, and we saw this after 9/11. The first 26 weeks, if you have to lay off individuals, or if you're furloughing individuals or you're reducing their hours, right, they can get partial unemployment benefits. Those individuals will be able to get unemployment benefits, and you are the chargeable employer, right? You'd be the chargeable employer. But for benefits beyond 26 weeks, and I would bet there's probably going to be benefits beyond 26 weeks when it all shakes out, those would be picked up by the government. And sort of everybody pays. But for the first 26 weeks, it's going to be easier for employees to be eligible for the unemployment benefit. Yes, the employer, you will be chargeable. But beyond the 26 weeks, if a state, depending on the state's unemployment, if the state's unemployment goes to a higher level than the national level, then those states would be able to exercise the ability to extend unemployment beyond 26 weeks. And from what I see here and my best interpretation, that would be covered by the government, not by the chargeable employer. So there are three components to this 6201. We're going to see more and more and more information about this and what it actually means for your business in the hours and the days to come. I think that where it gets the one question that I have that I'm wrestling with, like right now this morning, my group is wrestling with it. We're discussing it internally. We're going to blog about it. We're going to get that answer. We're going to get that clarity up on our blog page momentarily. Is whether or not is there an opportunity to say we already provide the paid leave component. We're already mandated to pay paid leave in the circumstances, and so we're going to pay it. So do I have to worry about this component if I don't want to have to worry about another thing that I have to administer? Because I'm already mandated by, for example, maybe Chicago or Cook County, my local, my state. I have local and state sick leave pay that I have to pay. Why would I have to pay this in addition to that? We're working that wrinkle out, and I just don't have a clear answer for you at 10:32 a.m. on March, I don't even know what day it is. March, was it 19th? March 19th. But we will get that information. We're looking at that. We're talking to contacts in Washington as we speak, and we're trying to get that clarity to our clients and to our friends immediately. Objectives in formulating the response. So this gets into, what do we do when there is somebody tests positive? What do we do if there's a presumption of somebody having the virus? What do we do to lower the impact of COVID-19 in the workplace? Responding to it. We've got clients responding to it, and we're hearing all kinds of different scenarios. We're, as you can imagine, we're being bombarded with questions. That's good. It's a good thing. Of course, we're trying to reduce transmission. Of course, we're trying to protect our workers and the public. Of course, we're trying to maintain business operations, trying as best we can to minimize the adverse effects on supply chain. While workplace wage and hour mandates, discrimination, termination, and other HR and legal regulatory requirements are secondary at this point in time, in my opinion, they are still important to recognize and note. The plaintiff's bar is paying attention. They're already advertising how to sue your employer for the COVID-19 response. Were you out of work? Were you forced to stay at home? Did you perform work at home? Did you get your paid leave benefit? I mean, those inquiries and that marketing is already afoot. So just something to recognize, pause, and note as we try and navigate as best we can. Now, I want to talk briefly about essential versus non-essential business. I'm getting a lot of questions of, Jeff, I make baby formula. If somebody tests positive for COVID-19, do I have to shut down my business? No. In fact, you're probably under order to continue the business. The second question, Jeff, I make potato chips. Do I have to? But I'm in an area where the governor said only essential businesses are to remain open. Do I have to shut down my business? Boy, I hope not. I love potato chips. We need potato chips. Yeah. I need you to make as many potato chips as you possibly can right now. Don't lose our minds, folks. Take a step back and let's say non-essential businesses in some of these, and I'm looking at Governor Wolf's order in Pennsylvania. His order was, hey, if you're not an essential business, I mean, like a gym, yoga, and spin facilities. Actually, in the order, he put spin facilities, hair salon, barber shop, nail salons, casinos, concert venues, theater, sporting events, golf courses, stopped, close, temporarily shut down. But essential services, and depending on now that order, and again, keep our heads on, they're not necessarily saying they're ordering to shut down. I mean, that's getting into martial law. They're saying we want you to, we encourage you to. And there are some ways that they can stop events, right, from certain number of people congregating. The government has the ability to do that for sure. The essential services, when you look at these orders, because the devil's in the details, right? If I'm looking at these orders or these proclamations from governors, mayors, they're not giving you a list and saying if you are in these service areas, these are the only services or businesses that can remain open. They're not saying that. They're saying, similar to Tom Wolf's recommendation, or whatever you want to call it, his order, essential services and sectors include, but are not limited to. And then there's this list, and the list goes on and on and on, including manufacturing, agriculture, food processing, construction, grocery stores, convenience stores, gas stations, pharmacies, hardware stores, home repair. I mean, it goes on and on and on. Insurance, banks. Governor Pritzker, I happen to be in Illinois. I kind of, paying attention to what Governor Pritzker is putting out. He has a ban out, right? Executive order banning public and private gatherings of more than 50 people. And everybody's like, well, I've got more than 50 people at my shop. I've got more than 50 people at my business. Does that mean I have to shut down my business? No. This is the essential business. His list of essential businesses was such, he used the word such as. And another way to put it is not limited to. So he was not, the Governor Pritzker's order was not meant to say, if you've got 50 or more people working for you, you've got to shut down. Oh my goodness. No, that's not what he meant. The Indiana governor has issued similar directives. So be smart, be wise, and be calm and in your approach, in your read of these orders. The devil is in the details. Now, shelter-in-place orders, similar questions. My local mayor has a shelter-in-place order. Look at the order. Just don't just hear about it in the news or read about it in the paper or look on someone's Facebook. Look at the actual order. San Francisco. They have a shelter in place. It excludes most business. And it's not an exhaustive. You see the list here. There's a lot of businesses that need to remain open. And it's not an exhaustive list. So where we're going, where we are today, and it could change tomorrow, it could change next week, it could change next month. But most employers are open and need to operate their business. When you get into certain personal, not healthcare, but grooming services, bars and restaurants, sporting events. Those are they're looking at that more of an entertainment value, and that is where the intent is behind these orders that you're seeing play out on a local and state level. Workplace practices. We got to send people home if they're ill. I mean, I've got clients asking me, Jeff, Phil came and he's he's coughing. What do I do? I'd send him home. Phil, man, go home. Figure out what's going on. I mean, I don't want people working who have fever, cough, shortness of breath, body aches. I mean, those are the symptoms. That's the CDC. I said those are the symptoms. So more and more employers are coming up with a practice of having signs out. If you have these symptoms, do not walk into this office. Do not walk into this production plant. Go home, call your doctor. We can't have people showing up to work ill. Some clients and more employers are requiring the temperature scans at the start of each shift, especially in that if they can't have that personal space in production, manufacturing, food processing, people in close corners, tight corners, working side by side. Even with a 6 feet space, there's a lot of people in a warehouse setting or a production floor or a plant setting. It's hard for us to say do it. The EEOC, the DOL just came out yesterday with, hey, employers, you want to do it, do it. It's not going to violate the ADA. So if now we're not announcing and we're not disclosing people's name and their body temperature to the masses, we're keeping it private. We're obviously there's common sense being injected into this process. Of course, we would have to have personal protective equipment for the people that are actually doing that infrared, no oral. It would have to be infrared scans. But anyone with a temperature, I think the temperature is 100.4. In fact, I'm telling clients if it's 100 or above, I would say, hey, you need to go home and get checked out and see if you make sure you don't have the symptoms. Not saying you do, but for everybody's benefit, including your own health, you need to go home and give it a few days, make sure you have no symptoms, and you are talking with a medical provider, your physician, doctor, and getting input from the medical community as best you can, and see what they have to tell you, and then contact us and let's see what your situation is in a day or two. I'm going to talk more about that in a minute. We're obviously emphasizing coughing, sneezing etiquette, hand hygiene, the no contact policy, the 6 feet rule policies. I think that those are important. I think those are good, especially if I've got we got to be creative. Stagger the shifts, less bodies at certain times, especially in locker rooms. Close off the break room, cafe. I don't want people eating together. That's gross right now. I mean, can we put a step forward using and trying to inject some common sense here? What are some things we can do to try and be a little safer? Encourage that private transportation to and from work. I've got businesses that are actually, hey, to encourage you to get private transportation, we'll pay for your commute mileage. We'll pay for your parking. We will reimburse you for mileage up to X because it's not needed. It's a commute, so you don't have to be reimbursing it. Even if you said, we'll pay you $10 a day to help you with the gas. Just be creative. You know your area. You know your geographic area. You know where your workforce lives and how they need to come to work. figure out ways to make it as efficient and as safe as possible for those workers to get to work. I have other clients. Just got to give you some information. You know, in the manufacturing and processing world, where they are, you know, instead of 10 people on the line, they've got 6 people on the line, and they're trying to make more lines. They're trying to figure out ways to have the production go forward as best they can, with maybe a little bit more space in between. So they're coming up with ways and creative ways to try and diminish those risks. You know, the cleaning, the personal protective equipment, you have a duty to maintain. OSHA requires you to maintain a safe and healthy workplace. That's your general duty as an employer. You're going to be judged, not today, not tomorrow, but in you know, a few months, 6 months. I mean, you're going to be judged. There's going to be a tidal wave of every decision you make being judged and second guessed. It's coming. It's a reality. What are you doing today to show and demonstrate that you are doing everything in your reasonable power and control in light of your means to continue to operate, but also to try your best to reasonably provide that safe and healthy work environment? Your cleaning procedures, your cleaning rules, your personal protective equipment, that's all going to be asked of you, possibly, potentially, in a short while. What are you doing? If you have an employee who thinks they may have been exposed, I mean, there's a lot of people that are sick that are being ordered, stay at home, self-quarantine. You have all of the symptoms, but what is a test going to do for you right now? We have limited tests, number one. 2, do you really want to go to the medical facility? You really want to drive? If you have no underlying health condition, you are in a certain age category. What I'm hearing is a lot of medical providers telling their patients, stay at home. I presume you have it, and let's see where you are in 14 days. That's happening, ladies and gentlemen. If that's happening, if there's a presumption that somebody in the workforce has developed COVID-19, or they've been diagnosed, they actually do have the test, or a family member at home has the test, employees should be instructed to inform HR or to inform the person in charge of the personnel function within the company, within the organization. And if there's a confirmation or a presumption by a medical doctor that somebody does have it, the employer should inform the employees that have been with direct contact with that individual of possible exposure. But you have to maintain confidentiality. You can't tell the person's name. You can't give the name, but everybody's going to know who the person is, probably, right? But you can't voluntarily divulge that name. You've got to maintain confidentiality. The best, you can't mention the name. Don't mention the name. The employees can mention the name, but you need to dampen that as much as you can. You can you're encouraged to contact your local health department for guidance, but you do not have to shut down. For now, we can manage this, and we're going to talk about managing it here in the next slide. So we want the employee who tests positive or presumed to have the virus by a healthcare provider, meaning, hey, I'm not going to test you because I'm not going to waste the test. You're a healthy, young female, 35 years old. You have no underlying health condition. Your symptoms, you've got a fever, you've got a cough. We're going to get through it. Let's monitor it every day. But I'm not going to waste a test on you. Or I'm not going to have you expose other people by coming down to the medical facility. Let's presume you have it. Those employees, again, they contact HR. They need to identify anyone they've worked closely with in the prior 14 days, customers, vendors, coworkers. You're going to we want to identify who they believe that they've had direct contact with. Number 2, undertake a deep cleaning of all affected workspaces. And yes, that there's a lot to that, right? I mean, boy, and this person's in the warehouse, they're touching everything in a warehouse. How do I do that? As best you can, as reasonable and as best you can. If shared building or area, notify the building management so they can take any precautions as they deem necessary. This is the important one. Employees with contact to the employee who tests positive or is presumed to have the virus, they need to go home and they need to monitor themselves. Fever, cough, aches, difficulty breathing. If they develop any of these symptoms, they must contact a healthcare provider. They need to stay home until the doctor says they can return to work or are free of fever, signs of fever and symptoms. I should probably, we put may want to demand both. I probably need to change. That was yesterday. I think today I'm saying I'm going to demand both. Yeah, I'm going to change that. I'm going to put I want both. I want a healthcare provider to give them the green light. They can do that by phone. They can do that by phone. They can send an email. And I understand we don't want to. The problem with this is, do we want to overtax the healthcare system? We've got to be sensitive to that, right? Those healthcare providers, those responders, they need as many resources as they can, and they can't be diverted with stuff here and there. If everybody called them, they'd be overburdened, right? That can't happen. So we want to be smart with that. But if we can, I would want to have both. Hey, you've been free of these symptoms without any sort of medication. You are symptom-free for at least 20. This is the CDC guidance. This is not my guidance. This is coming from the CDC. You need to be symptom-free for at least 24 hours, or you need the doctor to say they can go back to work. They're not at risk. Some employers, and I'm starting to lean that way, is when we can ask for both, I would ask for both. Some employers are going beyond what the CDC is saying, and they're saying 24 hours, I want them to be symptom-free for 2 weeks. Okay, that's fine, but are they able to, is that now going to kick in the paid sick leave? Probably, right? If I'm telling them to quarantine and I'm ordering them to, I think that would be a hard time for an employer not to pay the sick leave for those 2 or that period of quarantine that the employer is ordering the employee to take. OSHA considerations. OSHA came, I don't know why OSHA, they came out and they wanted to remind, I understand why they did it. They wanted to remind employers, this was in early March, they wanted to remind employers that you have a duty to identify and remediate known hazards in the workplace. If a known hazard can be corrected, you've got to correct it. You have to keep logs of injuries and illnesses. Now, here's the thing. Do you know if somebody contracts COVID-19, do you know that they can contract it in the workplace? I can see if the employee is in the healthcare field, and that's different. But general industry, beyond medical care, healthcare, that would be a unique set of facts, remarkable set of facts to require an employer to say to OSHA on the log, Phil contracted COVID-19 at work. I'm not recommending that. I think that is a stretch. And in fact, OSHA has come out, I think came out yesterday or the day before with, some people are interpreting our initial publication and announcement on this in much more broadly than what was intended. If you are in the medical field, healthcare field, and there's an employee who develops this illness, that is where I would spend time to consider careful consideration of reporting that, logging that in the OSHA logs. But for those that are not in the healthcare field, how would you know how somebody contracted the COVID-19? That would be a stretch where I sit here today. Okay. So going back to the paid leave policies, what's your current policies, right? You have to apply your current paid leave policies, and you can't now. I guess prospectively you can change the policies. You can change your paid time off programs. I mean, absent a collective bargaining agreement situation, if I've got paid time off policies, I should be evaluating right now. You should be evaluating your paid time off policies in lockstep with House Bill 6201 that was just signed into law, and reconcile it to determine what do we need to do, what should we be doing from a legal standpoint, from a moral standpoint, to help our employees, and also to discourage people showing up to work with potential COVID-19 exposure. If there's anything to take from today's webinar, I would be encouraging all of you to relax your no-fault attendance policies. Be sure to note that this is purely for COVID-19 outbreak, the pandemic. I would be looking at ways to, I understand you've got a business to run, but limit the ways, hey, if you are sick, if you're ill, if you've got the symptoms, if you are taking care of somebody with the symptoms or have been diagnosed, if you're unable to work remotely, then we don't want you at work, and we'll pay you for that time period to get through this. And it's that 2-week period seems to be the what the CDC is recommending. So trying to come up with some flexibility within your existing policies, reconciling it with 6201, and coming up with a nice, clear plan. And folks, what you do for your warehouse people may be vastly different with what you come up with your office people, and vice versa. There's not a one-size-fits-all approach to this. You look at it by the type of work people are doing and the geographic location and where they're doing it. FMLA, as I said before, the FMLA law didn't change. You still have FMLA to be concerned with and to administer, and to make sure that you are providing up to those 12 weeks of job protected leave. Now, remember something that I want to note here, and for all of this, if I have to go through a mass layoff, if I have to tell people, we have to shut down, I'm not. If the person is not working for me anymore because I've terminated maybe temporarily, hopefully the idea is to get them back. But if I've implemented a mass layoff, or if I have to lay somebody off temporarily, they're not. I mean, the FMLA is, they don't have the protection of the FMLA or the ADA or the paid sick leave. These laws are in place, and we have to follow these laws. But we're going to treat the employee and give the employee benefits, allow them to access benefits as active employees. And so so what I'm trying to convey here is, if I have to go through a mass layoff and Bill is going to be part of the mass layoff, he may be dealing with COVID-19. If he's part of the layoff, and regardless of whether he came up with the COVID-19 or not, if I have to lay off Bill in other positions and he's just part of the mass layoff, this, FMLA and other laws are not going to protect Bill. I'm treating Bill as if he didn't have COVID-19. He's just part of that decision making. He's impacted by the neutral decision that I have to make that may adversely impact him. Just moving on with FMLA, I do think that if a healthcare provider orders someone to self-quarantine, I think it's very likely FMLA, and they have that job protection. You can get treatment by phone these days or by web, especially right now. Physicians, doctors are treating patients and talking to patients by phone and by web. Don't get in, don't believe that they actually have to physically be seen by a healthcare provider in light of what's going on in order to be protected by FMLA. Let's see, ADA considerations, just word to the wise. If we're telling somebody to if somebody comes with the symptoms and we tell them to go home, self-quarantine, aren't we regarding them as disabled? Right? I mean, I probably. So they have some protection under the ADA, or somebody obviously has complications or permanent effects of this illness as we go forward. The other one that's a reminder, it's sort of a sobering reminder for employers, is association discrimination. That's a theory of liability. You can't discriminate because Bill's wife has COVID-19, and we're going to terminate Bill because his wife has COVID-19. That's obviously, why would anyone do that? But that's association discrimination, and that's a recognized theory of liability under the ADA. I anticipate we might be seeing that type of theory in the months to come. Just keep in mind there are a lot of angles that an employee can try and utilize to get, to be considered disabled under the ADA and have some of those protections under the ADA. All right, so FMLA ADA compliance recommendations, strategies, a lot. I know there's a lot to maneuver here. I mean, we could break down any of these topics today and do a 2-hour webinar on any one of them. The long and short of the FMLA ADA compliance, be aware, be cognizant of the FMLA ADA issues. They have not gone away. They're not suspended. We've got to tackle those, right? Engage the employees in interactive process, which means, let's talk to our employees. If they have symptoms, if they have needs at home, if they have childcare issues, if they have family member issues, encourage them. Call HR. Call your manager. Let's have a discussion. Let's figure out what we're going to do and how we're going to do it in real time, unique for you, employee. We want to be consistent in treatment of employees. We're looking at this virus, and COVID-19 is a very unique situation. But how we treat employees, if they're in the same job or similar job, working in the same areas, locations, departments, working under same supervisors and chain of management, we want to treat those employees and the rules that we apply, we want to treat them certainly fairly and equally. The employee pay, we've already talked about this, but something you need to understand, the salary. If I have an hourly employee, now that hourly employee may be eligible for paid time off under 6201, local, state, and your own benevolent policies. What I want to talk about now is this whole notion of making sure that we are properly compensating hourly employees and salary exempt employees under the FLSA and as well as state law. Remember, if an hourly employee can't work because of their own illness or quarantine and they're unable to work and they're unable to telecommute, there's paid leave, right? There's paid leave there. We've got House Bill 6201, we've got your own policies, we've got local and state mandates. They're going to get some component of paid leave for a short duration. I'm sure of it. With a salary employee, just remember, because when an hourly employee doesn't work and they've exhausted their paid sick leave, they're out. They're out. If they can't work, they can't, and then that's why the unemployment system is there. For salary employees, salary exempt employees, if they work at all during the work week, you generally have to pay them. Now, if they exhaust paid time, now if they only work, if today I work Monday, but I can't work the rest of the week because of sickness, if I've got a paid time off program, we all have paid time off programs now. Most people have paid time off programs, or you've got local and state mandates. You've got House Bill 6201. If they have paid sick leave or paid time off available that they can implement for sick leave, you can take from that bank, right? You can always take from the bank of sick leave, of paid time off. When they've exhausted all paid sick leave, they have no other paid benefits. If they work at all during the week, you've got to pay them for the full week. However, if they miss full day increments because they are voluntarily deciding I can't work, if work is available and an exempt salary employee cannot work a full day because they need to take that full day off, and they are voluntarily seeking that full day off, it's initiated by them. You don't have to pay them for that full day, provided that they miss a full day. You can dock them for that. For time off mandated by the employer, you have to pay them for the full week in which they work any time during that week. So this is where I'm segueing into the furloughs versus layoffs. If I have a lot of employers now calling me saying, I want to implement a furlough. Okay, you want to implement a furlough. If you're going to implement a furlough, if that exempt employee works at all, because you're initiating it, employer, this is what you're requiring. You're mandating it, not the employee. If they work at all during the week, they get their full salary. In order for you not to pay them for that full work week, you would have to furlough them in a full week increment. So let's talk about furloughs and layoffs. A layoff is a termination event. They're eligible for unemployment benefits. They're eligible for all earned wages at time of separation. If I lay somebody off, whatever paid time off they have available, they have available. Now, do I have to pay them the paid time off under House Bill 6201? No, I don't think so. I mean, because they haven't triggered it, right? They haven't triggered it, and if they're not actively employed, they wouldn't be protected by House Bill 6201. So a layoff is a termination event. The employment relationship ends. A furlough, employment remains intact. Now, they're still eligible for unemployment benefits because if they're not working, then they can get unemployment even though the employment relationship is intact. But the employment relationship has not been formally, technically severed. So they would have opportunities to take advantage of whatever benefits are available to them because they are actively employed. You need to identify the differences here with your health and welfare plans, your retirement plans. You need to have, and if you're not completely, if you don't have complete clarity, talk to your health and welfare plan broker. Talk to your retirement plan administrator. Make sure you understand the impact of a layoff versus active employment versus employment being terminated, even temporarily through a layoff. Also, keep in mind that you can, like the paid time off prospectively, you can manage and modify wage rates and salaries. I mean, of course, if you're subject to a collective bargaining agreement, that's different. or if you have a contractual obligation, but generally, most employers have the freedom to modify wage rates, salaries. Now, I'm not recommending employers modify wage rates for hourly employees that are working in food processing plants at the moment or medical supply production facilities at the moment. In fact, I'm hearing employers that want to give those types of workers more money to incentivize them to show up and produce. But salaries, now I'm starting to hear, okay, maybe we do an across-the-board reduction, or maybe, we layer it, maybe by levels, right? We might layer it by 10%, 15%, 20%. As long as we're meeting minimum wage, as long as we're meeting any sort of contractual obligation, as long as we're meeting the salary level minimums, that is legal so long as we do it prospectively and we do it across the board with similarly situated employees. Short-term disability benefits, somebody becomes ill with the virus, they may be eligible for benefit. They may be eligible for the benefit. It's going to come down to the terms of the policy. I don't know what your policy allows or excludes. I've seen short-term disability that specifically has exclusions for pandemic. So the devil is in the detail. It's unique to the actual benefit plan that you have available if you have that type of plan available. Typically, disability policies don't provide any benefits or protection where an employee is unable to work due to self-quarantine or mandatory quarantine situation. Unemployment benefits, we talked a little bit about the expansion of that. If somebody is ordered to quarantine, if you order somebody to quarantine, if you do a temporary slowdown or shutdown, remember, employees should be encouraged to apply for unemployment benefits. They could be eligible. They probably will be eligible for some partial benefit. You can collect unemployment and get a check from your employer at the same time, depending on how much they're getting paid and the state unemployment programs available for that individual unique to the state. An employee refusing to work due to fear of catching the virus. At this time, that's likely refusal of suitable work. For example, the Illinois Unemployment Office already came out with guidance. Hey, if you have employees that are not working because they're afraid to work, they're not eligible for unemployment. Note that the plaintiff's bar is looking at that fear factor as a possible theory of retaliation down the road. I'm fearful of a workplace hazard. Well, what workplace? Right? I mean, that's I'm afraid to come to work because I'm afraid to catch the virus. Okay, why? I just am. That's not good enough. I need you here. If you're not going to come here, I'm going to look at that as job abandonment. And you can apply for unemployment, whether you're eligible or not, that's to be determined, but I got to have you here. I need you here. If you're not going to come in, that's either job abandonment or refusal to work, insubordination, whatever you want to call it and manage it in real time. If somebody says, I'm afraid to work because my coworker, you just informed me, my coworker was diagnosed. Well, first off, I would say I would not be if somebody was diagnosed, tested positive with COVID-19. Why am I forcing their coworkers to come to work? That makes no sense. Remember what I said earlier? I'm probably telling them stay home, make sure you have no symptoms. CDC says for at least 24 hours with no medication. I may go so far to say self-quarantine for 14 days. There's paid time off available for you for that, and let's see where you are. Now, that person goes 14 days, they're symptom-free, they're clear, they have no symptoms, they need to now get back to work, in theory, right? And if they don't come back to work because they're continuing to be fearful, that I don't think that employee is going to be protected under that type of scenario. Labor relations. If you're in a unionized work environment, there's additional considerations. You have collective bargaining agreements. I'm sure those collective bargaining agreements, now they're not all created equal. They're different. Look at your management rights. If I'm a unionized employer, I am of all the things that you've got to do, add this to your list, review your management rights section. You inherently have the right to operate your business how you need to operate your business. If you need to make decisions when you're weighing your next move in the operation of your business, I can't speak for the labor unions, but one of the things that I would think most business agents that I know would happily have a conversation with you about how do we creatively continue to operate without having to go through a mass layoff. So let's talk. Let's try to work something out that is good for the workers and good for the employer to continue operating. What I'm trying to get at here is if you're going to change economic terms and conditions, if you need to change work rules that could result or may result in discipline, those are subjects of bargaining that you'd want to flush out with the bargaining representative of your unionized workforce. Have those conversations. If you look at your operations, what do you need to change? If making changes violates your collective bargaining agreement, don't feel paralyzed. Take proposals to the business rep. See if you can get an understanding. These are unprecedented times. Let's figure out how we're going to move forward as best we can for both the workforce and the company. It's in everyone's inherent best interest for that company to survive and sustain itself and maintain operations going forward. And we get through this. Work compensation, workers' comp. If an employee contracts COVID-19 from a coworker, will they qualify for work comp benefits? No. I mean, unless, again, healthcare workers, that's where this would come in. I've been exposed because I'm in the trenches here helping people with this virus. That, similar to OSHA, similar to the OSHA log and the recordable illness, would be sort of the same rationale and line of thinking with work comp. So the question is whether it rose out of employment. That's going to be very difficult to prove absent or outside the healthcare field. Work comp is the last of my concerns right now. But I get that question a lot. Well, what if they what if they get this virus at work and now it's going to be very difficult for them to make that connection, extremely difficult for them to make that connection. And I can't keep saying, if I was a work comp lawyer representing employees, do I really want to take that on? It just seems like a financial mess in order to try and prove something like that. But we'll see where that shakes out. But that's the last of my concerns right now. Fear of infection. And we've already talked about this. An employer is not required to accommodate employees' fear of infection. Now, that could lead to treatment for anxiety. If they're actually seeking treatment and obtaining treatment for anxiety or depression, that could trigger some FMLA issues. That could trigger some ADA issues. But just fear alone, just flat out, I'm not coming to work because I don't want to get it. No. That's too plain. That's too simple. That doesn't fly. Push back, employers. Get to the root. What's going on? Are they sick? Do they have a family member sick? If not, you need to come to work unless there's been exposure. Unless there might be. We're not saying you were exposed at work. If there was a COVID positive at work, or a presumption of being positive with COVID-19 at work, and they had direct contact with the worker, we're probably going to do some sort of quarantine for those direct workers for a little period of time, right? We've talked about that already. But unless that remarkable circumstance is in play, I am not going to accommodate fear of infection, just a blanket fear of infection. WARN. We got a lot of questions on WARN. There's federal WARN law. Federal WARN law, we've got you've got these mass layoffs and plant closings, and Real quick, if I have to do a mass layoff, if I have to shut down and displace a number of employees that would trigger federal warrant, and really you're looking at around, when you start looking at around 50 people, 50 full-time equivalents being out of work, you're really looking at that number of 50, that's triggering conversations with your lawyers, okay? I know that under federal warrant, I have to give 60-day advance notice. But remember, even under federal warrant, if we're dealing with 50 or more, and those are that starts the conversation, right? Because there's a lot of nuances with warrant. I always say when you have 50 or more people you have to lay off, talk to your attorney about possible warrant issues. Federal warrant would only apply if I know that those 50 or more people are going to be out of work for at least 6 months, okay? If they're going to be out of work for at least 6 months or more, if it's a temporary layoff, right now I'm going to lay off 2 weeks, lay off a month. I don't know if this is going to go beyond that. I don't know. The legal position that I believe this is sound is I don't have a warrant event yet. I probably don't know. Now, I'm speaking generally. Maybe you do know. Maybe the question will be, what did you know at the time of the layoff? And that's unique. That's unique with circumstances, facts, your type of business. But a lot of employers, generally speaking, are saying, I might have to do a mass layoff for 2 weeks and see where we are in 2 weeks. But when you know that the layoffs may last at least 6 months, that's when you still, even though you might not have that 60-day notice, you still got it. At that point, you've got to send notice to the worker, to third-party representatives, i.e. the union, to government bodies. That notice is still going to be required at some point if you trigger federal warrant. Again, I've not heard a suspension of federal warrant, so it could come. It could come, but I have not heard about it. It's just something for you to consider. The long and short of it is, for federal warrant purposes, that advanced 60-day notice, have those conversations with your counsel, legal counsel. When you have 50 or more people that you need to lay off, start having those conversations with legal counsel. What are the effects? Because there's also state warrant laws to worry about. And those are different. What applies to federal warrant law might not apply to states. Now, California has a warrant law. They have one of the most restrictive warrant laws in the country. The governor of California, I think it was yesterday, just suspended warrant in California. Also remember that notice requirement, that faltering company, unforeseen business circumstances, natural disaster, doesn't say pandemic, right? The pandemic, the COVID-19 is probably the unforeseen business circumstances. That's probably what it is. That's probably where there's an exception there. But again, notice is still required. It's still required at the time that you're going to conduct a mass layoff that you think may last 6 months or more. You might not be able to give 60 days because of the unforeseen business circumstance. It's just interesting, California didn't recognize the unforeseen business circumstance, so I think that was part of why Governor Newsom was able to, or was willing to suspend California warrant. Otherwise, California employers would have been hammered by the lawyers when this thing blows over. Additional considerations. Consider and review your insurance policies. You probably have already been doing that, right? What is your business interruption policy? Do you have that type of coverage? You should be talking to your broker, your property and casualty broker. If you haven't, you should be having those conversations with your brokers and with your business advisors on your different types of insurance that may play into this pandemic and what's going on. Evaluate your technology infrastructure. I mean, it's probably, you know, I mean, maybe it's a little too little and late, but you should be testing those infrastructures. You should be looking at, you know, what can we support? What if this is long term? What do we do to try and continue operating remotely as best we can? Review business continuity plans. You know, meeting. I'm preaching to the choir. I know that, but you know, regular daily or weekly calls. What is the continuation? How are we today? What do we need to be tomorrow? Review your borrowing needs. Looking at your lines of credit. Review your financial obligations carefully. Bank covenants. What do you need to do to reserve cash? Reserve capital now. Do it. And then our blog updates. We may, by the time I'm done with this, I may have already updated it. We're monitoring 6201. I've given you the summary. The summary is on our blog page, laborandemploymentlawupdate.com. It kind of, you know, goes through, and the one wrinkle that I have is the whether or not it's that in addition to language would play out, so that if I'm already giving the paid leave, do I have to give the paid leave under House Bill 6201 in addition to? We're figuring that out this morning while I was on the webinar. People a lot smarter than me are looking at that further, and we will be updating our blog page on that specific issue shortly here. Thank you all for attending. I know there's a lot. I wish I had a crystal ball. I wish I had the easy button. I don't. I am imploring my clients and my business contacts to reach out, have conversations, have dialogues. What works for your unique business is going to be fundamentally different than your neighbor to your left and to your right or down the road. This is really a local, the local issue first and foremost, then state, regional, national, international, and it's fluid. I'm telling you, I'm just repeating what you already know. But please reach out to your counsel, to your business advisors, and be safe. Thank you, everybody.